KPMG, offers damages to the appellate division. You are here, the attendance shall be heard. Please be seated. Good afternoon, and welcome to the Appellate Division First Department. We have 4 hours of requested argument time. So I'm going to ask that you ask for the time you actually need, not the time that you want. Understanding we are familiar with your briefs, the record, oftentimes more than you wish you were. So, and please know that the clock is for you, not for the court. So if my colleagues have additional questions beyond the light, I let it continue to go, okay? So if you are absolutely brilliant, you can have all the time in the world, all right? That being the case, People versus Corey Brown. Oh, good start. Submitted. S. Nadia. Oh, we are on a roll. Submitted. Brown versus Voda Realty. Okay. All right, 7 and 2 and 5. Brevit Direct Lending versus Aprio and BHSC Global versus Aprio.
For Appellant Brevit, Your Honor. My name is David Bain. I'm a partner at Aikman LLP, and I'm here with my partner Ryan Williams of the Bar of Illinois, who's been admitted pro hac vice, and I'd like to request that he argue this appeal.
Okay, that application is granted. Although we have over 100,000 lawyers in New York, you are welcome.
Thank you. Thank you, Your Honor.
How much time?
7 and 2, please, Your Honor.
Okay, and who's next? Okay. Okay. I'm feeling generous today, so 7 and 2, 7 and 2 and 7. Don't get used to it. That doesn't happen often. Yes. Garcia versus Saint Spriden Greek. Submitted. People versus Shamar Gardner is submitted. Morand versus Coachman Luxury.
Your Honor, I'm here for defendants' respondents, but if the appellants aren't here, I will submit unless there's questions.
Submitted. Thank you. Have a seat until we finish the calendar. Thank you. Pogle versus KPMG.
Gary Pogle on behalf of the plaintiff. Good afternoon, settlement.
Okay.
Good afternoon, Justine Abrams from the Luxury Council on behalf of respondents. Seven, please. Here with my colleague Peter Hughes, who is granted pro hac vice admission.
So I'm not going to go through it again. Welcome. Okay. We're going to do on this one, I don't think that the issues are that complicated. So 5 and 1 and 5, and like I said, if my colleagues have more questions, they'll continue. Okay. Sagai versus DHCR. Okay. All right, I'm going to do 5 and 1 and 5. People versus Anthony Gregg. Okay. 3 and 1 and 3. And KLG Jewelry versus 706 is a submit. First case on the calendar is Brown versus Voda.
May it please the court, my name is Nicholas Herzler. I represent the defendants' appellants in this appeal. Your Honor, our position here is that we should have been granted, first and foremost, a comparative negligence charge. I mean, I only need a little bit of evidence to get a comparative negligence charge, and in this case, we have a lot of evidence.
Also, in this case, the super pokes around the ceiling with a broomstick, as I recall, says maybe a few staples or whatever. Why, under the circumstances, would the plaintiff think there's a dangerous condition when the super seems to believe it's not an issue?
Well, the plaintiff, it's a fair inference, Your Honor. Under the loose standard for a comparative charge, the plaintiff's wife testified, quote, I told him that the ceiling was collapsing. That's at 167 of the record.
Told who?
told the super, and the plaintiff said that he was there when his wife complained.
Right, but the super, after poking around, as my colleague pointed out, didn't come back to repair in any timely fashion, right? I mean, why would he believe that it was imminent that the ceiling would be falling?
Well, because his wife got that impression, and he
Is she a contractor or something that we should give some heightened level of weight to her impressions of the ceiling?
No, Your Honor, she's not a contractor.
Okay, so we have a superintendent who pokes at the ceiling, and if it was about to imminently fall, the poking of the ceiling should have done that.
Your Honor,
You can have a sagging ceiling for 2 years and it not fall. So the fact that it's sagging by itself is not an indication that it's imminently going to fall, especially where there's no water captured within the space. And he poked at it. If there were water, water would have spilled out of the hole.
Your Honor, it was their testimony that there was water coming down, but the point is it's...
But no, they said, let's be accurate. They said there was water that was dripping into the wall and out of the window, not through the ceiling. Nowhere does it say that, right?
It was coming down the wall from the air conditioner, and I don't... Your Honor is right. I don't have any testimony to say that there was water coming from the ceiling, but he said it was sagging. It's a fair inference that he knew it could come down. That's what his wife said. They were both in the apartment.
But who would be in the best position to make that determination? The wife, the plaintiff, or the super?
Any one of the three, but it was their theory that the defendants were on notice of it and that it was for...
It's not a theory, respectfully. It's not a theory. It's fact. Your super inspects the ceiling, doesn't find it to be dangerous, says it needs a little bit of work and leaves and never comes back. That's what happened.
But they argued to the jury successfully that it was foreseeable to the defendant that the incident could occur. And so how is it negligence?
That's
for
why
us?
they complained to the super, because they felt that it needed repair. But after his inspection, he decided that all it needed was a few screws, and that was it. That it was safe.
But how is it negligence for the defendant but not for the plaintiff? It can't be-
Counsel, you know the rules here, right? You don't get to ask the court questions. That's not how this works. So it's real clear. You are asking us to impose some responsibility on elderly tenants, because we're talking about a 75-year-old man, and I'm assuming his wife is close to that age, right? And so you are asking us to impose the duty on these elderly people to assess the imminent collapse of a ceiling instead of the superintendent whose job it is to do that.
Your Honor, I'm not asking to impose a duty on them. I'm just saying, first of all, they don't dispute that he could have very easily, moved the bed or go to the other bedroom. That's all he
It
had.
wasn't a bed, it was a couch, right? So every night he should move the couch from the wall?
It was a twin bed.
Okay.
Right, the other room that you're talking of was reserved for his son when his son comes to visit. But, I mean, and who are we to say how somebody lives in their home? The issue really here, that you're trying to deflect with that particular point. The issue here is that the super came, poked around, left, and did not come back to make the repairs. Even if he said repairs were necessary, he never came back to do that. I think you should move on to another point.
Okay, I'll move on to the argument about the building code, because I think it was a mistake by the lower court to charge the building code, and actually, as a matter of fact...
That was not the objection that was made to the court below. The objection was not that the code was not applicable because the building predated the code. The objection was that the code was not applicable because this did not involve a fire.
Your Honor, that's true, but he used the word applicable. He objected twice, and that's close enough under the cases that we cite.
Just with the word applicable? So anything that falls under applicable, even if I don't articulate the argument specifically, is enough?
Your Honor,
I think the construction law bar and the labor law bar would be appalled at that suggestion.
Your Honor, he only has to, under the case law that we cite, he only has to articulate something that's Close enough. He said this code is not applicable. It could have been more artfully worded, yes. Also, the court has the power to reach this issue in an exercise of discretion under cases like Huerta and Highbridge development that we cite.
Even if you were correct, why wouldn't, under the circumstances of the case here, why wouldn't that be harmless error? Given that the super was in there, did the inspection, was on notice of a condition, why wouldn't that be sufficient for a jury to find liability?
Well,
Just under the common law standards of negligence.
because the charge is a very strong one, because the charge says shall, it says ceilings and walls shall be maintained in a safe and sound condition, and that's a very positive command without any notice element or anything, so the jury could hear that and decide, well, based on this code, we've just
But
decided.
doesn't the multiple dwelling law also require a building to be maintained in good repair?
Yeah, and honestly, I mean, think about what you're saying. What jury, what person who lives anywhere would not think that a de minimis standard is that your walls and ceilings should be in good repair? I mean, I don't think this is like a huge stretch.
Well, no, Your Honor, but there's no notice element. And to answer your question, Your Honor, the plaintiff withdrew the multiple dwelling law charge because when they had that conversation, the plaintiff said, I would rather have the fire code charge instead of the multiple dwelling law. So this was the only code that was charged. So how can we say it's
It would
harmless?
be an inference of negligence in any event, correct?
No, because it says shall and there's no notice element. It's not the same as negligence because there's no notice element.
Was notice really at issue here?
It's a huge, they kept argued in their summation, they kept arguing up and down that according to the super going up there and seeing it and the complaints that was noticed that this was foreseeable, which again, if it's foreseeable to us, I don't know how it's not foreseeable to the plaintiff, but I see my time is up.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the court, Michael Zhu, appellate counsel to Harris, Heenan, Goldfarb.
Counsel, why don't you begin there with the fire code issue and why that isn't reversible as opposed to harmless error?
Well, as Judge Singh pointed out, the elements of a prima facie negligence case was established through the evidence at trial in terms of the defendant had notice of a hazardous condition that they did not remedy in time. Having established that the ceiling should have been properly maintained, it's the same elements as what the fire code requires. Although the word shall is in the code itself, all that means is that that's equivalent to what the common law standard requires.
Violation of a code is some inference of negligence, correct?
Yes.
What was charged here? Was it the statutory provision charge or just some inference of negligence?
There was some inference of negligence.
So it's not, so the jury, in other words, based on this charge and the maybe wrongly cited fire code, didn't have to find
Correct.
that there was liability, correct?
Correct, Judge. Yeah. So as we argued in the brief and below too, that even if this charge was given in error, it's harmless because the jury could have reasonably reached the same conclusion in finding that the defendant failed to maintain its premises in a reasonable condition based on the common law principles. As to the one argument that was not raised before, the missing witness charge for Dr. I forgot the name. I'm just going to call him Dr. K at Allborough. There are two issues with that. One, notice. The defendant first pinpointed to the exact witness who they wanted at the charge conference after the plaintiff had already rested. Prior to that, they said, oh, I think I need a missing witness charge because he should call somebody from Allborough Medical without naming the name of a doctor. There are several doctors there. It's unfair to the plaintiff, and it's a surprise, and the trial judge pointed this out. You can't bring this up at a charge conference after the plaintiff has already rested to then say for the first time, you should have called a particular doctor to testify.
Regardless, if they had brought in that doctor, would his testimony have been cumulative?
That was going to be my very next point. It would have been cumulative because Dr. Gutstein reviewed, first of all, the Allborough medicals were already in evidence. Dr. Gutstein reviewed the medical records. Dr. Gutstein testified as to the treatment that Mr. Brown received, and was cross-examined on these issues by the defense counsel. So anything that would have been brought out through testimony from the treating doctor would have been cumulative because all of that was already covered by Dr. Gunn.
And those medical records were admitted into evidence
They
without
were.
objection.
Without objection.
And quoted by the defense expert.
Yes. And unless there are any further questions, I'll rest on the brief.
Thank you.
Thank you.
You have 2 minutes.
I can explain why it was not cumulative. It would not have been cumulative. First of all, the plaintiff has the burden to show that, which they didn't submit any evidence that it would have been cumulative.
Don't you have to assert the need for a witness before the party rests under our rules?
I'm glad Your Honor brought that up because, as a matter of fact, the plaintiff's brief doesn't cite a single case or law or anything on that. Nothing. So.
Okay, well, I believe that there is case law on that issue, so do you want to answer my question? The law says that before you seek a missing witness charge, you need to notify the other party that you will seek a missing witness charge so that they have an opportunity to call that witness instead of suffering the missing witness charge. So was that done here prior to the resting of the plaintiff's case?
Your Honor, it was not. However, the point here is that they always knew who these doctors were. I can only respond to the arguments that my adversary made, so I'm not prepared to respond to that because they didn't make that. They didn't cite anything on that. So the point, though, is that here's Dr. Carafin treated for 22 months with this plaintiff. He had at least six detailed treatment reports. He certainly knows a lot more than an IME doctor who is going to come in for the first time 2 years after the accident and examine someone and look at records, especially because we wanted to cross-examine him about pre-existing conditions, degeneration.
Did you learn, was this doctor on the witness list for the plaintiffs and they didn't call him? Or did you know from the beginning of the trial that this witness was not being called and you chose not to object until after the plaintiff's case had rested?
Your Honor, I don't know that. My adversary didn't make that argument, so I don't know how to respond to that. But the point here is that they had the burden of proof, and it's just I can't understand how an IME doctor in a case such as this could be the same as a treating doctor who has so much knowledge that he could be cross-examined on. And they don't cite any cases to say that we had to notify them. And by the way, they always knew there were only 2 treating doctors from Aldborough, only 2. And Carafin wrote all the treatment reports. So I don't know how they can say it's suddenly a big surprise. We don't know who this doctor is. I mean, of course they knew who he was. So with that, I'll rest on my brief.
Thank you. Brevit Direct Lending versus Aprio and BHSC Global versus Aprio. So Brevit and BHSC should be on this side, Aprio should be on that side. Yes, whoever is on 5684. Okay. You may proceed.
Thank you. Good afternoon, Your Honors. Ryan Williams on behalf of Appellant Brevit Direct Lending Short Duration Fund. It is an honor to be here, and I thank you for your time. May it please the Court. Your Honors, this case involves an engagement in which Aprio was engaged to confirm accounts receivable and a cash account that Aprio knew was going to play a large, if not
What was the engagement standard here in the agreement, and what was the standard alleged in the complaint here that was breached?
So, Your Honor, the agreement sets forth the consulting standard as opposed to the attest standard. And also in the complaint accurately stated that the agreement set forth the consulting standard.
So aren't you bound by what you say in the complaint that it is the consulting standard that applies? Presumably that's how discovery was conducted, based on that standard.
So that's actually incorrect in terms of how discovery was conducted, Your Honor, because this issue as to which standard applied, whether it be the consulting standard or the attest standard, was hotly debated during the discovery. The complaint drafted at the onset of the litigation.
Was the complaint ever amended in light of this contesting of the standards? Because we have a complaint that talks about consulting standards. So it's nice that there's discussion and debate, but unless I have an amended complaint that changes the theory of the case, I'm stuck with a complaint that asserts a consulting standard, and I am bound by the four corners of that agreement.
So a few points on this, Your Honor. Number one, to answer your direct question, no, the complaint has not been amended. Number two, this issue came up during discovery at length. It was the purview of expert opinions, both by Brevit and by Aprio. During the testimony that Aprio provided, Aprio openly admitted that when engaged in confirmations, there is not a consulting standard that provides any applicable guidance as to how confirmations are to be performed. In addition to that, our expert opined that various of the things that Aprio did have an attest function. They made a—
That's all very well and fine. The problem is you have to modify the agreement to change the standard in order for another standard to apply. So tell me, what communication, what change was there officially from a consulting standard to an accounting standard that would permit us to switch gears and have that standard apply to this scenario?
Yes, Your Honor, thank you. So the engagement agreement expressly contemplates additional services, additional representations, engagements under the engagement agreement.
Well, it said these services may be changed or modified by mutual agreement of the parties.
Correct.
So I searched the record to see whether there was some mutual agreement of modification by the parties that I could discern from the record. I found none. So you tell me where I can find it.
Well, Your Honor, I think we need to look no further than the report itself, where it says, in addition to, right at the beginning of where they make the representation that these receivables were directly confirmed, it says, in addition to the prior procedures, we have also agreed to do confirmations of these accounts receivable. And at the end of the day, there is simply no standard under the consulting standards that covers confirmations of accounts receivables.
So wouldn't it have been incumbent in light of that change to make sure that we're all on the same page in terms of the standard we're following? Because it seems to me that you're saying our people understood they have to do confirmations. That's not a consulting standard, that's an accounting standard. So where's the email that says, oh, by the way, this new duty you have on this IPG transaction, we need that under the accounting standard? Where can I find that communication, that explicit direction in the record?
And one other thing, just to add to the question that Justice Mencelet Daniels has made, is that the engagement letter specifically says that the performance of services does not constitute an audit conducted in accordance with generally accepted auditing standards.
So, Your Honors, that communication does not exist, to answer your direct question.
Okay.
But here's why.
I appreciate that answer.
And Judge, here's why, or I'm sorry, Your Honor, here's why. Because ultimately, we find ourselves in terms of a disparity of information and knowledge. We are retaining an expert to go and perform confirmations, to confirm that these accounts receivables are real and are not fake. And so for us, Brevit, retaining an expert to say, oh, and by the way, under this new engagement for which there's no consulting standard that applies, we are requiring you to use attest standards. It really feels not only like an impossibility, but ultimately—
Why is that impossible? I don't know. Stop. Why is that impossible?
Because
you reach a transaction, right? You hired them. They utilize the consulting principle for initial work, and now you have this IPG transaction that they want to consider a different deal, right? And this deal obviously requires different, don't worry about the time, I'm gonna give you more time since I'm asking you a long question, okay? So they have this new deal, and it's clear from what I'm reading that, yes, I don't disagree with you that a different standard should have applied, but nobody said it out loud. You assumed that they would do that. I don't see anywhere where there is a direct communication, like, guys, on this one, this is what we need. Where is that?
So, Your Honor, again, that communication does not exist, but I wouldn't call it an assumption. I would call it a presumption, because ultimately, what is the purpose of retaining an expert and paying them?
What is the purpose of a contract that doesn't say what you needed to say, allows you to modify, and you don't take advantage of that?
So, fair point, Your Honor. If I may just say that even under these consulting standards, even under the consulting standards, we still need to see an exercise of professional judgment. We still need to see that the supervision is.
But then that's not the standard we're using. We're talking about gross negligence here, right?
Well, so ultimately, what the case law in New York says, and ultimately why we contend that the judge really usurped the role of the jury here, is because she made a finding that Brevit did not put in any evidence to establish either that Brevit had breached its own internal procedures, or that it had breached any industry standards in terms of performing this confirmation. And that is simply not true. We identified numerous instances where Aprio violated its own internal procedures in terms of how it performed these obligations. And literally, how it performed these confirmations was to be passively CC'd on emails sent by the target entity upon whom the due diligence was being done. So literally, they admitted during the deposition that they allowed the target entity itself, for whom they were performing the due diligence on, to perform the confirmations itself. In addition to that, we have a lengthy expert report that we submitted, and it talks about both the consulting standards and it talks about the attesting.
But going back to the underlying agreement, not only does it say we're using consulting standards, it also says in performing our services, the defendants are relying on the sufficiency, accuracy, and reliability of information provided by the targets. So it seems to me that when I look at this language, there is no requirement to confirm the emails. Maybe hindsight, it only took about 10, 15 minutes to discover the fraud, but that's with hindsight.
Well, Your Honor, I would contend that there is a requirement to keep the client abreast of significant issues that are occurring. And what we see in terms of red flags that were spotted, we see emails from Aprio to Kingston Smith, who it retained in the United Kingdom, in which they say, we're not receiving information. These guys are running us around in circles. These are directly between Aprio.
But it sort of goes back to, it sounds like what you're arguing is negligence. But it sort of goes back to, it sounds like what you're arguing is negligence, and as my colleague suggests, and it's really not gross negligence.
Well, so, Your Honor, I would disagree with that, because, I mean, ultimately here, the only thing that was done to confirm is to be passively CC'd on emails. That's it. Right. And in addition to that, so the court already found that the failure to use confirmation.com constitutes a basis to get this to a jury for gross negligence.
Because nothing was done. And in that circumstance, nothing was done.
And nothing was done in this circumstance.
That's not accurate. They relied on the information that was given, and then they opined on that information.
And they continually said they were relying on the information that was given.
But to Your Honor's points,
I'm going to give you 30 more seconds.
To Your Honor's points, these multiple acts of negligence, they can't simply be considered in a vacuum. They can't be looked at independently and say, this one's negligence, this one's negligence, this one's negligence. Under New York law, you are entitled to look at all of these multiple acts of negligence, not in a vacuum, but in context with one another. And when you look at all of these acts together, at a minimum, there is a question that is sufficient to submit this to a jury.
Thank you.
Thank you.
Counsel, I'll hear from you now. Yes.
I'm next, right?
Yep. You're against Aprio, right? I'm gonna have the two of.
I'm I'm Frank Franzino for BHSC.
Right. You're against Aprio, no? Right, okay. You may proceed.
Frank Franzino for BHSC, and with me is my partner, Aaron Corman. What I think is important in this case is this draft report.
Could I ask you to move closer to the mic so we can hear?
Can you hear me?
Yes,
There
now.
was this draft report, and the draft report was in October, and it said certain things that there were problems with the confirmation, that it went through management, so on and so forth. Then, when we get the final report in November, that's scrubbed out. And so our contention is this could be very clearly an intentional scrub out. It's certainly a question for the jury to see if that's intent.
Are you suggesting that your client didn't know anything about what was going on? Brevit is frankly in a different position than your client. Wasn't
Our client hired these people to be
Was your
experts.
client involved in any aspect of the due diligence?
Yeah, Mr. Merchant did ask that it be directly confirmed. He did ask Aprio, please directly confirm the accounts receivable and the cash, because it's so important. This was 8 million pounds. This was the most important thing. So he was looking for a direct confirmation.
But when Griffin sent out the email to Aprio saying, listen, if we allow you to do it directly, then our clients are going to say, this company is being sold and it's going to be affecting us. So can I simply contact them, have them send you the information, but let me do this for you so that we don't get harmed in the process. And that was communicated to Merchant.
That was communicated
And
to
he
Merchant.
said, fine, go ahead and do it that way.
But, Your Honors, I'm an attorney. I have clients telling me things all the time, and it's my duty as an attorney to say, no, you can't do that. And that is the duty of Aprio.
But again,
say-
when we go back to, it seems to me that you're advocating for the higher standard, frankly, the auditing standard, as opposed to what the agreement provides for.
Well, doing the auditing standard because it's very clear in their final report that they're taking on this role of direct confirmation. And in fact, if they were,
You were the client seeking the direct confirmation, correct?
why would my client, I'm sorry, Your Honor. I
Answer
asked
my
the question.
question.
I asked the question and I'm sorry.
Yeah,
I
we
was
don't
so
allow
bad.
that. Okay, so.
Okay.
It was your client and Brevit who was seeking the confirmation, correct? Okay, so you both know what the contract says, that it's under a consulting standard. So if this was so important, then why not make sure that this review was happening under the standard you required in order to make sure that if you made this investment, your companies did not lose your shirts?
Your Honor, that's a question then. My client would have to know the difference between a testing standard and a consulting
I
standard.
think if
Shouldn't
your
the
client
question,
was
Your Honor,
about to invest in a $78 million,
Oh, it's a big investment. Yeah.
okay, so, and he doesn't know that.
And refresh my
Wouldn't it have been-
recollection,
I'm
counsel,
sorry.
refresh my recollection, what was the business experience of your client? I'm talking about Mr.
My
Merchant?
client was an accountant.
And was he also an MBA, as I recall?
One of them was.
CPA or
Yeah.
MBA?
One of them was.
Mm-hmm.
But it's clear from cases we cited that the accountants can't rely upon, pass off their professional responsibility to a client. I cannot do that as an
No,
attorney.
but a client, but the company you hire doesn't have to say, yeah, we should upgrade this contract because this isn't gonna cover you. And in fact, they kind of told you that. They continually kept saying, they kept saying, we can't, there's a lot of stuff, right? Merchant says there's a lot of stuff caught up in this AR. We should third-party confirm some of it.
That's what merchant wants.
It was clear, right?
What merchant wants what he got.
So
A
if
direct-
he as a astute person in this field would have been the one person who knew that the standard needed to be upgraded, yet there's no statement anywhere making sure that that's what's happening.
But Your Honor, again, I say, it isn't the responsibility of the accountants to say to the client, what are we doing? We're trying to get a direct confirmation, but we're going about it, which is not proper, because we're letting the target company control it. I believe you're trying to say is that it's the duty of the client to say this, but I'm
No,
saying,
I think what the issue is, counsel, is that normally we don't read duties and standards into contracts that aren't there. And that's what you're asking us to do under your interpretation.
well, but doesn't an accountant or an attorney have certain standards, Your Honor?
I don't know if you're asking me a
And
question because I don't think so.
the standards are, is that they cannot supersede its judgment for a client's. And that's exactly what Aprio did. And it's really, I think, a question of fact for a jury. I don't think it's a question that we could sit here all day and try to figure out these factual issues. And in fact,
What's the question of fact? Whether the defendants here should have modified the contract that they were hired to do on their own in order to provide their clients with what they thought they should get but didn't contract for?
shouldn't the accountants have told us?
You're violating the rule
No,
of
shouldn't the
asking
accountants have-
questions of the court throughout your entire argument, counsel.
Well, I'm trying, Judge, I'm trying. I've only been around a few years, and
That's okay.
I've been very calm.
All right.
Okay. I think that the issues here is, and we have this case, this Nova Scotia case, which I think
But in
is
that particular
directly to the
case,
point.
there were auditing standards. I mean, and they violated their own internal controls. Again, we keep coming back to what was agreed upon. What does the engagement letter say? And that wasn't the situation in the Nova Scotia case. You're already starting behind wherever they started off from.
But Your Honor, they meaning Aprio, sends out a confirmation letter. And in it, it says, send it directly to me. And lo and behold, the supplier does not send it directly to Aprio. It sends it to the bad guys, the fraudster. So they violated their own internal procedure.
Thank you.
Thank you, Your Honor, and I'm sorry if I asked.
No, not at all. No need to say sorry. Counsel, I'll hear from you now.
Good afternoon. May it please the court. Matthew Ferlazzo with Hinshaw and Culbertson for the respondent in both appeals.
Counsel, oh, go ahead.
How do you respond to your adversary's position that says there are no standards under the consulting standards that apply to confirming accounts receivable, that when you were confirming accounts receivables, that you had to apply the auditing standard?
I'm sorry, Your Honor, that we had...
That you had to apply, there was nothing else to apply
There was
to
nothing...
the auditing standard? Or the
because
attestation standard?
It goes back to what did the parties agree to. And the
right,
parties...
no, that's clear, right? I think it's pretty clear that we understand that what the agreement was, it was a consulting standard. But when you're asked to do a confirmation of accounts receivable, and that's not included within the consulting standard, what are you left with?
You're left with the agreement saying that the client will direct the procedures
Well, what
to be
about
followed.
the testimony of the person from Aprio who basically says, yeah, we knew that this was what the standard was supposed to be when we're doing that kind of work?
The testimony from Mr. Rawls from Aprio was in relation to general discussions about that, yes, the auditing standards do set forth confirmation procedures, but he was clear also in that testimony that they did not perform an audit in this case, so it didn't thereby automatically make those standards applicable.
It's curious because your adversary raises the October report, the draft report, and in that draft report, it specifically said management provided no documentation. So it seems to me that when you get to the next report, all that language is excised. Doesn't that suggest maybe that there was a modification of the services, more services were provided because in the November 2016 report, it also recites that the lender has requested confirmation of customer receivable balances.
In that report, Your Honor, though, it does also note that this is not an audit examination or review in accordance with established.
Well, they're not asking for summary judgment. They're saying they're issues of fact.
Right, but when you have the report issued in November specifically saying it's not an audit, it's not being done pursuant to the auditing standards, that thereby takes away the argument that there was some change. Now, I understand there's also questions about the changes in the draft, but those changes are not the red flags they make them out to be. In many cases, they are information that both...
So let me ask you a question. So your company's hired on the consulting standard, and part of what they're hired to do is to advise these companies on potential acquisitions, right?
Yes.
Okay. So call me crazy, but it seems to me that a first level confirmation should be the people who we're engaging with actually work with the company that they say they're working with. That seems pretty basic. Why isn't that covered under the duties of a consultant who is consulting on the issue of whether I should acquire this company?
Because the sophisticated parties in this case agreed in their contract that the procedures that would be followed would be dictated by the client, and also agreed in the...
Well, I thought they were dictated by the consulting standard.
They're dictated by the client, and they also were in conformance with the consulting standard.
Okay, so the consulting standard means what? We accept whatever you say, we check nothing, and we just sign off?
It doesn't say that, Your Honor, but we did follow to the extent, there was use of judgment. There's questions that they've raised about subordination to judgment that are incorrect.
So I'm just, look, it took, like my colleague said, 10 minutes to discover that these were fraudulent emails to companies. So what did Aprio do in order to confirm that they were dealing with legitimate parties? It seems that's like just basic.
If I could just mention one issue, Your Honor, I think it may...
No, I need you to answer my questions.
Answering your question with the premise that it took 10 minutes, answering that question, Aprio followed the procedures that were agreed upon with the client as was set
Which was
forth
what?
in the contract.
Spell it out for me.
They were that there would be a preparation of a confirmation form, that form would be
So
sent
the
by Mr.
party
Griffin.
is going to verify for themselves that they are who they say they are. Is that?
No, Aprio prepared the form. IPG, Mr. Griffith, would then send it. That procedure was agreed to by Mr. Merchant from BHSC because Mr. Griffin had raised issues about the potential issue of stepping in between the client relationships. So again, there's a preparation of a form by Aprio. Mr. Griffith sends out the forms, copying the Aprio person. The forms come back, executed, again, directly to, though, Aprio in this particular situation.
So again, the answer to my question is yes. The target confirms their own information. There's no, based on what you just said, there is zero independent confirmation of anything.
But that's what
Zero.
That's what the parties agreed to, Your Honor. And this was not as
And
clear.
that's in conformity with consulting standards?
It is, Your Honor. And this wasn't a 10-minute thing. There were multiple law firms, there were multiple accountancies involved who looked at various different parts of this transaction, including the contracts supposedly with these counterparties. Nobody else discovered this fraud either at that time.
Counsel, will you agree that to confirm accounts receivable, that the proper standards would be to apply the auditing standards?
I would agree if that's what the parties agreed to, Your Honor.
That's not the question. The question is that to confirm it properly, you would have to apply the auditing standards.
No, Your Honor, I think it's governed by the parties' agreement. I think the auditing standards set forth
Listen to my question.
procedures.
I'm not asking you what you agreed to. I think we all understand that you agreed to the consulting standard. That's a given, right? At least take it as a given for my question. My question is, for you to do a proper confirmation of accounts receivable, that would require you to apply the auditing standards.
No, Your Honor. The auditing standards have procedures in them for confirmations.
Are there standards in the consulting standards for confirmation of accounts receivable?
There are not.
So when you're asked to confirm accounts receivable, what are you doing then?
The first place you look is the parties' agreement. The auditing standards do not become automatically applicable.
In other words, the parties' agreement told you had to do nothing with regards to confirming accounts receivable. Therefore, when you had to confirm those accounts receivable, you did nothing.
No, the parties' agreement said you follow the procedures that would be agreed on with the client, and that is what was done, Your Honor.
Thank you. You have 2 minutes.
Thank you, Your Honors. I do just simply want to point out, you asked a lot of questions about what the consulting standards actually provide. And the consulting standards specifically require that there is a reliance upon sufficient relevant data. And so ultimately, as to your question about whether anything was done to confirm whether they were actually communicating with the entities that purportedly owed these ARs, they did absolutely nothing to confirm that they were. And this is all set forth in the lengthy expert report, which under Bank of Nova Scotia stands for the proposition, when you have an expert who comes in and talks and defines the standard of care, shows that they're, based upon the facts, was an extreme departure from that standard of care.
The problem you have here is that in Nova Scotia, as my colleague already pointed out, they had the right standard.
100%, Your Honor, but it is not the same in that I'm not saying it for the audit standard. I'm saying it for the concept of if you have an expert who who provides a report that says, here's the standard of care and there's an extreme departure from
So
it.
you're saying that they were required to, at the very least, say, what you're asking us to do should be under the auditing standard. And if you're going to make us do it outside of that, then we need sign off.
Yes, Your Honor. In addition to the fact that this engagement agreement, it behooved them, it behooved Aprio to have this deal close, because otherwise they only got 40% of what was otherwise entitled under the engagement agreement.
Counsel, but
So
didn't they in essence say that when they said when they communicated repeatedly that they're relying on the information that's provided to them?
So, Your Honor, these what I would call like disclaimers were included in the front. They were included in lengthy paragraphs of disclaimer after disclaimer after disclaimer. What we see in the actual report when it comes to the accounts receivable, it says, we were asked to confirm the accounts receivable, bold, italicized, directly confirmed.
So let me just see if I understand this. Anytime an accounting firm or is doing that kind of work, the auditing standard applies regardless of what is agreed upon. Is that your position?
It is the only standard found in the AICPA. It is the only place where there are standards for confirmation.
But then what you're saying is what my colleague has just pointed out. So you want this court to rule that regardless of what a contract says, we should impose a higher standard, a different standard, if we think the fact pattern called for it, irrespective of the fact that the parties did not amend their contract to that effect. That's what you're saying.
To Your Honor's point, if the fact pattern calls for it, and ultimately here.
What case allows a court to rewrite a contract in that way?
Your Honor, I cannot cite you a case here that stands for that proposition.
Because I don't think there is one.
I can tell you under the facts here that in their confirmation letters that they were allowing the target entity themselves to send, they were referring to themselves as auditors. I can tell you that they openly admitted that there aren't any standards for doing confirmations under the lower consulting standards.
I get it, but you're asking this court to rewrite your contract and impose a duty on the other side that is not within the four corners of the agreement. And I know of no case law that would permit us to do that, even if we thought it would be the right thing to do here.
So nonetheless, Your Honor, I think that ultimately here what we see are numerous violations, even of the consulting standards, which I think does require sufficient relevant data in order to make a representation such as directly confirmed, upon which Aprio relied in lending this $13.75 million to this deal.
Okay, thank you.
Thank you, Your Honor.
I'll hear you. Yes, you have 2 minutes.
Your Honor, I think try to synthesize this. I think the key here is the final report we get, and it says directly confirm.
But I acknowledge it says that, but there are many instances, and I can recite you the record page numbers, where it says we're performing this under consulting standards.
But it's-
So it doesn't suggest that there really was, as the briefs argue, a change in the standard through the due diligence process.
But what, if any client receives a statement, a report from a big accounting firm saying it directly confirms, when the accounting firm could have easily said in there, but, like it said in the draft report, but there were problems. That is my issue here. They didn't do that. And I think that that is something which a jury has to take into account, and that's why we should be in front of a jury to take this whole question of gross negligence and what it is, so on and so forth, into account. And that's what I thought that case was good, the Nova Scotia case, about basically we have negligence, which I think the judge sort of thought we had, but do we have gross negligence? And the Nova Scotia case says, let it go in front of a jury to decide. And that's what we're asking, Your Honor.
Thank you.
Thank you, Judge.
Moran versus Coachman Luxury. Oh, no, sorry. Pogle versus KPMG LLP. I forgot this one got submitted.
Good.
You may proceed.
Thank you so much. Good afternoon, Your Honors. Gary Pogle on behalf of the plaintiff appellant. Disputed issues exist as to whether child care played any role in plaintiff's termination. If I may, I would like to begin with that part of our case.
Well, actually, why don't you focus on this point? Because I know that there, inside the record, there are numerous recounts of underperformance and declining assignments. And I'm not necessarily sure what job, what case law would find issues of fact when you have these non-discriminatory factors that come into play as to why someone might be terminated. Why should we go so far as to see any issue of fact? There's so much in the record of underperformance, which is what I think the company hung their hat on.
Well, to counter that, there's multiple performance evaluations some days before the document was issued that was used to fire my client, the low performance memorandum. All of these documents, reviews, were noting that he was operating at next level. That's the highest level of competency at KPMG. Okay, there's so much documents on that, performance reviews from managing directors, from managers. Again, I think just a few days before this memo, this defamatory memo was issued. So, as far as pretext.
And then let's stop there because you just mentioned the defamatory memo. Defamation, how? These are internal documents. They weren't publicized anywhere but amongst the people who worked at that company?
Your Honor, yes, statements made to co-employees can be actionable. Even if this court finds that privilege applies, it can be overcome by a showing of malice or reckless disregard.
And how did you show that?
Okay, if I may go through that. For example, on February 13 of 2020, there's an email from KPMG's HR, and that's page 559 in the record. It says, by the way, this is in the pre-pandemic time, nothing in his file indicates that there's an issue with his work product. In addition, that email notes...
I'm sorry, that was not responsive to my question. How is that responsive to a showing of malice?
Yes.
Counsel, I need you to answer the questions of the court, okay? So I asked you, show me where in the record there's evidence that there was malice. I looked at this record. I didn't see any.
Irrespective of this email, they still pursued the low performance memo. The author of this memo, admitted that this memo was hard to piece together. He said he was tasked with writing a memo that would be used to fire the employee. And he is saying that's why this.
Are you contesting that your client declined a number of assignments in New York? Because I think that your client was completely justified in saying, I'm sorry, my wife and I just had a baby. I'm not traveling to San Francisco for months at a time. So I think he was completely justified in that. But then after that, he was given assignments in New York. He accepted them on Monday, and then on Tuesday, he called and said, I changed my mind, I'm not taking that assignment. So, and he did that several times, okay? So explain to me why that is not sufficient justification to show that his work product and his delivery of work had suffered.
I have an answer to that, Your Honor. Page 558. In February, he's 90% chargeable doing work for which he was hired.
February when?
Of 2020. It says 90%. What this means is that he's doing
This
work
is before the pandemic, right? Before it really kicked in.
before, and after we have
Right.
111%, 97%. This is all M&A work.
And we have 17% and 20% and 37%. So we've got a lot of percentages.
We're talking about the utilization rate. Are you talking about that? Because his utilization numbers were not that high. They were more in February of 2020, they were around 9.8, which was one of the lowest utilization rates among all senior associates. And then it might have went up to maybe 29% in April of 2020. But I don't know what are you using your 90%?
And the standard was 70%, so.
The standard for M&A tax, all employees have to be judged by impact metric, which my client exceeded in July, okay? I don't know where they came with the standard that they're just gonna look at utilization for 1 month, maybe January. Every employee has to be treated the same. Their own HR department said M&A tax has to be, you look at impact metric.
Okay, you'll have time on rebuttal.
May it please the court, Peter Hughes with Ogletree Deacons for the respondents. I know I'm not supposed to ask any questions, but I guess I would invite any questions from the panel.
Well, I have a question.
That question is okay.
Why do you say there are no issues of fact as to actual malice?
There's no issues of fact as to actual malice because the author of, I mean, are we speaking specifically about the low performance memo?
No, I'm talking in general. Why, assuming that there is a common interest, the common interest privilege applies, and surely it does, because there's an interest in plaintiff's performance. But why do you say, in general, no issues of fact have been raised as to actual malice?
Because there are no issues of malice, there are no issues of fact on malice because the authors of the statements either had personal experience with the plaintiff and it was what they believed, or it was information they had gathered. For example, Mr. Ziegler gathering information from others who had worked with the plaintiff. He spoke to them, he got feedback from them, he got emails from them. We've provided a lot of documentation. It's not like he just sat down and wrote something in a vacuum, and therefore he reasonably relied on those things. And there can't be malice because they believe them to be true. Malice requires that they know they are untrue or act recklessly. So, just one other thing that counsel had addressed here, we were talking about utilization and percentages. The critical evaluation for the interim review was what was your year-to-date utilization. Counsel, when he says 90%, is talking about 1 month of utilization in February of 2020. After he's told by multiple people, you're not working and that's going to be a big problem, that's when he suddenly is able to find enough work to give him 90% for 1 month. So, I don't know if your honors have any other questions I'd be happy to answer.
Your adversary also raised the assertion on the discrimination claim that he was treated differently from similarly situated employees. How do you respond to that?
He was not, as the trial court found,
Why is that?
because he was the lowest utilized person. He was among the most experienced. He may have been the most experienced senior associate. The expectation is that somebody who at that point had 6 or 7 years as a senior associate is going to be among the most in-demand people.
Well, no, I understand that, but in terms of his childcare responsibilities, which you know, it's commendable that he takes them seriously, was he treated differently than, say, some of the women who were in those positions?
No, he was not, Your Honor, because he never requested a flexible schedule.
So you're saying he's not similarly situated to them?
Not similarly situated. He's comparing himself to managers. He's comparing himself to people that were on leave and not getting paid at a time when he is allegedly working full-time and getting paid $160,000 a year.
And he was the highest paid
He was
associate,
the highest
right?
paid. There was one other male who was among the highest paid, yes.
Okay. Any others?
Thank you.
Thank you. You have 1 minute. I'll give you his extra 25 seconds. How about that? A minute and 25 seconds. I give you 25 seconds more. Go ahead.
Thank you. On September 5th, just a few days before he was terminated, KPMG's upper management is concerned that my client's childcare situation would be the case for the foreseeable future. They're not discussing performance. They're not discussing utilization. This is page 862. Why are they discussing my client's childcare situation and that will be the case for the foreseeable future?
Well, that was what your client said, no?
Yes, but this is just days before his termination. Clearly, this goes to pretext and violation of...
Well, pretext would require that there was no other information that would have supported this decision, and we know from the record that there was plenty. So you can't say it's pretext.
What I'm saying is that the jury may find that childcare entered into their mind when terminating my client because they're not discussing any performance issue, and they can't.
Your client was one of 1,400 people who were let go, correct?
Yes.
And it was part of an entire workforce reduction that had to happen because of the throes of the pandemic, right?
Yes.
And according to the HR witness who provided some information with regard to that, they proceeded in the terminations in an orderly way, marking the people who fell below a certain standard of productivity. And those were the first 1,400 they let go, and your client was one of them, correct?
Yes.
Okay.
But
and I have a follow-up to that. In the 1,400 people who were also let go during discovery, did you determine that, in fact, there were similar people with childcare? Were they the ones who were being let go? Is there anything like that? Or was it only your client?
only men. And on that list, the women who in their counselee forms, and I lay that out, say because of child responsibilities, I couldn't meet my metrics.
Right, but those women were in different situations, right? There were some who were on leave. For example, I think Ms. Tomasio was on leave. There were no utilization rates to meet, et cetera, et cetera. I mean, the ones you pointed out, haven't they shown that they were not similarly situated to your clients?
Ms. Choice Garcia came back from leave for 6 months. She was 8% utilized. Pursuant to the New York City human rights law, child care cannot enter into an employer's mind when terminating them. There's ample evidence that I lay out in my brief that they talk about child care. For example, on February 4th.
No, we've got that.
You got it,
We're not
okay.
going to go through that
So,
again.
I think the jury should be allowed to determine if child care entered into their minds. In light of so much evidence.
Thank you. We're out of time. Thank you so much. Sagai versus New York State DHCR.
Good afternoon, Your Honors.
Good afternoon. You may proceed.
Thank you. My name is Seth Schoenhaus of Legal Aid Society, counsel for petitioner appellant Zufan Sagai, and may it please the court. Respondent DHCR's decisions denying Ms. Sagai's rent overcharge and illegal deregulation claims were not supported by the record as required by this court. DHCR mischaracterized.
Didn't she move in after the apartment was already deregulated?
She did, Your Honor. She was the first resident of the apartment after the alleged deregulation in 2008.
Okay.
DHCR had mischaracterized the lower reviewer decisions by rattling off these cursory statements that evidence was actually weighed, when the decisions themselves give no basis to believe that that actually happened. And in fact, gave Ms. Sagai precious little information upon which to make this appeal, as DHCR cited no basis upon which it made its findings. Instead, the agency simply rubber-stamped the landlord's submission.
Are we talking about the same case? Are we talking about the same case?
What did you?
Because DHCR went through a lot of records here in making this decision. So I'm at a loss for that statement.
Well, the issue for Ms. Sagai was that the rent administrator and the deputy commissioner in the petition for administrative review didn't indicate that they reviewed even most of the records.
They say that they went through the entire rental history. They went back as far as 1984 in reviewing the rental history to make sure that any increases were legal.
Well, respectfully, Your Honor, they didn't indicate that the increases were legal. They didn't indicate that they went back that far.
What are you challenging? Are you challenging the IAs? I mean, what specifically are you challenging just now?
Both the deregulation and the lack of an indication that any of the factors of a fraudulent scheme to deregulate were ever examined in their totality as required.
What's the fraudulent scheme here? I think that's where we're having some disconnect. I mean, what is the fraudulent scheme? Is it the fact that repairs were made, insufficient repairs were made, no repairs were made, renovating the apartment? What precisely is the claim?
Well, only some of the repairs that were claimed to have been made, or I should call them alleged improvements that were claimed to have been made, were actually made. For instance, in the brief, I mentioned that there were light fixtures that were claimed to have been installed, and
your client says she doesn't know one way or the other whether they were because she's a new tenant. So I don't understand how that's evidence.
Well, she was the first tenant after these alleged improvements were made.
She testified that when she went to see the apartment, they were working on the floors. So there was obviously some work being done on this apartment when she came to look at the apartment.
Right, Your Honor, there was some work being done, but there wasn't enough detail given in the invoice or in any of the landlord.
Well, there's no requirement that a landlord provide a new tenant with invoices for repairs they're doing to their apartment, and I know of no case law that requires that, so.
No, Your Honor, of course not, but because she was made to sign this $10,000.
She wasn't made to sign. She could have said, no, I'm not signing, I don't see anything fixed here.
She wasn't, because she wasn't
She chose, she wanted the apartment, so now she says, I signed it because I wanted the apartment?
Right, but because she wasn't provided with a lease rider indicating her rights as the first tenant after deregulation, she had no basis of knowing that that was significant or not. So she could have turned away the apartment.
So you sign a piece of paper that you don't agree with because you don't know that it's significant?
Essentially,
I wouldn't sign a piece of paper that I thought was a lie just because.
I wouldn't have either, Your Honor,
Okay.
but we're attorneys.
So what are we supposed to do with that? I mean, I don't.
The issue and the thing that Ms. Sagai took exception to is that in none of DHCR's determinations did they indicate what evidence was reviewed and why, and what credibility determinations it was given, and what weight the evidence was given in their judgment. And so Ms. Sagai is respectfully asking for a remand to DHCR to actually.
So that they could tell her again?
If they tell her again with a thorough explication of the evidence they weighed and the judgment that they gave to that evidence.
And is there a case law that requires the kind of specificity that your client is asking for? Is there any case that requires them to do that?
I don't know off the top of my head the case law, Your Honor, but
I have a decision in front of me telling me that they have reviewed the rental history to 1984. They don't have to go through. In 1984, the rental history said this. In 1980, they don't have to do that from 1984 until 2023. So if that's the specificity that your client is looking for, she will never get that.
That's not the kind of specificity she's looking for. She's just looking for something beyond the bare bones, quote unquote, the evidence in the record indicates deregulation.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Christina Ossie for the DHCR.
Why is he incorrect that his client is entitled to know exactly what DHCR based their
Right, I think part of the
decision on?
confusion is the scrutiny, the level of scrutiny. There's a strict 4-year rule that would apply to a pre-HESPA overcharge complaint in reviewing the rental history for the purposes of determining if there was an overcharge. The tenant filed her complaint in 2018, so 4 years back is 2014, and on that date, the apartment was out of regulation. But to succeed on her complaint, she would have to show there was a fraudulent scheme, that they had been a fraudulent scheme.
So what evidence did DHCR rely upon when
Yes,
it
Your
looked
Honor.
over the entire rental history to determine that there was no colorable claim of a fraudulent scheme?
Yes, Your Honor. So the evidence that the owner submitted to support its claims was reviewed. It included the last stabilized tenant's lease, rent rolls going back, as was mentioned, to 1984, and then evidence of the IAIs performed in 2000. The owner claim was performed in 2008. There were also
Were the IAIs suspect because they were performed essentially where there was an identity of interest between
Right.
the super and the owner?
Right. When that was raised, the owner provided additional proofs to show that the contractor was paid separately from his wages as the superintendent. So that
Now, in
was-
this instance, there are not many records that corroborate, for example, the superintendent doesn't have records corroborating payments, et cetera, et cetera.
Right.
What's DHCR's position on that?
Well, Your Honor, the DHCR's position is that at this time, 2008, that evidence was sufficient to show that he did not perform the work at the time he was doing his superintendent duties. Again, had this been raised upon her taking occupancy, a more intense scrutiny could have been given because it would have been within the 4 years. But by waiting 10 years later, the level of scrutiny given was entirely appropriate, but not as intense as it would have been if this had occurred within 4 years of the filing of her complaint.
You heard your adversary say that she didn't know her rights because there was no writer saying that she was
Right.
the first tenant after that.
Well,
Is that an issue?
Well, no. I know that is not, under the Bronner case, which is cited in our papers, that notice, to the extent that it may apply, is not a condition of the deregulation, and that she did sign the PAR order actually says that by saying that agreeing that based on her inspection it had been the apartment got renovated, that she had some sort of notice that she could have come to the agency and then found out more. The owner did register the apartment as exempt for the 2009 and subsequent years. She would have been able to obtain that. I would just add that the DHCR did investigate the tenant's allegations of fraud, but found it was inadequate indicia. The focus of the investigation was on the pre-deregulation rent history, whether anything in that rental history could have tainted the amount of rent that deregulated the unit. And the DHCR considered the totality of the circumstances, and its analysis is consistent with this court's recent decision in Gassama. And the tenants claim that the owner's evidence is not credible. I would just respond that it's within DHCR's purview to determine.
It was late registration of some of the statements. Was that an indicia of fraud?
No, Your Honor. And I think that occurred to the extent it occurred very early on. again, if that issue is timely raised as to what the impact of a late registration would be, you know, that's a different inquiry, right? For this purposes of this inquiry, that was not sufficient evidence of fraud under the Grimm standard and under the new legislation. I would just say DHCR's job is to determine whether evidence is credible, and it did that. And insofar as there was insufficient evidence of fraud, there's no legal basis for the tenant's remedy, which she is requesting, which is in effect to re-regulate the apartment and to get the benefit of the default formula. Thank you, Your Honors.
You have 1 minute.
I would just note in response to my adversary that yes, while it's within DHCR's purview to make credibility judgments as to the evidence, that was never done until the Article 78 review at the Supreme Court. In fact, DHCR only mentioned that evidence did in fact exist in the record, but without an analysis of that evidence or any explication of its credibility determinations, there's no reason to believe that those were actually ever made.
Thank you.
Thank you.
And last but not least, People versus Anthony Gregg. You may proceed.
Good afternoon, Sylvia Lara Altruder of the Legal Aid Society on behalf of Anthony Gregg. May it please the court. Anthony Gregg's prison sentence of 6 years is excessive and should be reduced. Mr. Gregg was an essential worker during the pandemic. He has a young son and family waiting for him. He accepted responsibility by quickly pleading guilty in this case. With respect to his work history, as this court has held, a person's vocational skills and employment history are relevant at sentencing. These skills and ability to hold a job show that a person is willing to engage in their community and has the ability to lead a law-abiding life. Mr. Gregg has shown that willingness and the ability to do so. He signed up to work at Kings County Hospital.
The gravity of what was done here, isn't that also an important factor to consider?
Yes, and Mr. Gregg is not making excuses or not seeking to diminish the fact that he did something terrible. And he is serving a lengthy prison sentence for it.
I mean, as a result of his actions, 2 out of 3 men were hospitalized with gunshot wounds.
Yes, Your Honor. To move on, at sentencing in this case, Mr. Gregg's attorney said that he believed that it would be easy for Mr. Gregg to find work again, and so his hope is to return when he leaves Doc's custody and rejoin the community as a productive member of his community. With respect to his family, Mr. Gregg's son was born after he was sentenced in this case. He has been incarcerated his son's entire life. Parental incarceration has a significant deleterious impact on children, especially young boys who will go on to struggle in school. They develop behavioral problems. This is part of Mr. Gregg's story also, and he is eager to stop the cycle and return home to be with his family. And then lastly, Mr. Gregg pleaded guilty weeks after he was arraigned in this case. He didn't file any motions. He did not force the state to undergo the expensive trial. He didn't put either of the victims through the process of having
He got a very good sentence for shooting 2 people.
It could have been much worse for Mr.
Oh,
Gregg.
yeah.
There was a lot of exposure here, but he tried to do the right thing. He accepted responsibility when he was in.
So this was all negotiated with the prosecution?
Yes, Your Honor.
And he got, despite his criminal record, he got as Justice Manson-Daniel said, a pretty good deal.
Yes, Your Honor, there was a lot.
So you want a better deal now?
Yes, Your Honor.
We all do.
But we appreciate that in you, okay?
But to briefly address his criminal record, his prior record took place when Mr. Gregg was 16 and 17 years old. It was a different time in his life. There's lots of research.
So now this one took place when he was 10 years older?
Yes.
And obviously he didn't sort of like learn anything because he went ahead and he shot 2 more people.
I wouldn't go that far, Your Honor, but I only wish to put into context the fact of his criminal record happened when he was a teenager.
And then he was incarcerated for those years in between this. And, I mean, that's really not, I don't know if that's the flex you think it is, honestly.
I'm sorry, I don't understand.
He's been in jail for 10 years and then comes out and shoots 2 people.
Not long after being released.
My point was only that with respect to his prior record, it was very serious, but just to put into context that he was very young when those offenses happened.
Thank you. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Peter Rienzi on behalf of the people. As Your Honors have noted, and my adversary noted as well, defendant was permitted to plead to significantly reduced charges in this case, and obviously the exposure that he was facing was significantly higher than what he was sentenced to. Despite that favorable bargain, he is now asking for the minimum sentence on those reduced charges. This sentence, Your Honors, was not unduly harsh and severe. In fact, it was lenient considering the violent conduct, the fact that it was his 4th felony conviction, all of which had involved violent or dangerous conduct. And again, he had received the sentence that he agreed to in exchange for pleading to those reduced charges. In short, none of the reasons advanced by defendant on appeal would warrant reducing his sentence. If there are no questions, we would ask that you affirm.
Thank you.
I'll just address one point briefly. Mr. Gregg did agree to this sentence, but that is not this court's only consideration in evaluating whether it is appropriate. For all of the reasons that we cite, the impact on his family, his commitment to his community, we ask that his sentence be reduced to 5 years. Thank you.
Have a good evening, all.